This case starts exactly where most defendants never want to be, already on probation for a second-degree felony involving a deadly weapon. From the very first question, the tension is obvious. This isn't about whether rules were broken, the defendant admits they were. The real question is whether this court believes she deserves another chance or if this moment becomes the turning point toward a possible 20-year prison sentence. And what happens next proves just how thin that line really is.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes.
Are you okay?
Yes.
You're getting white. She's getting white.
We are.
Give me just a second to get that flipped up.
Our agreement, Your Honor, is for her to be on special needs safety.
Thank you. Sorry, it's taking a minute for my computer to get pulled up here.
Your Honor.
Okay, so Ms. Williford, in cause number 24, DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that...
We've agreed to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for
Here's where the legal situation tightens fast. Probation isn't a suggestion, it's a contract with the court. Positive drug tests, failure to complete court-ordered programs, and unpaid fees are some of the most common reasons probation gets revoked. And notice how methodical the judge is here. Each violation is read, confirmed, and admitted on the record. When a defendant pleads true to multiple violations, the court already has the legal authority to revoke probation entirely. At this point, leniency is no longer guaranteed, it's discretionary.
tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
True.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today. And is that the recommendation from probation as well?
Yes.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
There we go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. Looks like there's some...
This is a critical courtroom moment. The judge clearly states she has enough evidence to revoke probation right now, which would likely send the defendant to prison. But instead, the court chooses an alternative, extending probation and ordering placement into a special needs safety program. That's not a soft decision. It's structured accountability. The added year isn't a favor, it's a warning period. The court is essentially saying, this is your last window to prove you can comply.
Everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the Special Needs Safety Program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had a statement prepared for you, explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never touch this shit again if you let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am. I didn't mean to. I'm terrified.
This is where emotion collides with courtroom reality. The defendant tries to explain the marijuana use, referencing cancer, pain management, and even invoking religion. But courts don't operate on emotional promises, they operate on compliance and respect. Judges expect defendants to understand the gravity of where they stand, especially when facing decades of incarceration. This moment shows how quickly sympathy can evaporate when a defendant crosses professional boundaries or appears to minimize the seriousness of their situation.
I'm so sorry, ma'am. I just didn't realize how much trouble I'd get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to...
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff.
Actually, it went better than I thought it would, actually.
Really?
This is one of the times it's great to have off camera.
This reaction says everything. From a legal standpoint, this outcome did go better than expected, but that doesn't mean the danger has passed. The judge made it clear, any future violation could result in prison time up to 20 years. This is one of those rare courtroom moments where the camera captures the aftermath, relief mixed with fear. And it reinforces a hard truth: surviving today's hearing doesn't erase tomorrow's responsibility.
Oh.
She's never seen me. I'm literally biting my tongue.
You just never know.
Jesus is what?
I mean, you use the F word and Jesus in the same sentence. I feel like that's a problem.
She said friggin'.
Well.
You know what she meant. I know what she meant.
Kashma Thomas, Mr. Rojas.
I told him this before.
This case is a textbook example of how probation works, and how fragile second chances really are. The defendant admitted to multiple violations, yet the court chose rehabilitation over incarceration, extending probation and imposing strict conditions instead of immediate prison time. But the judge's message was unmistakable: this is the final chance. If you found this case as intense and revealing as we did, hit that like button, share your thoughts in the comments, and subscribe for more in-depth courtroom breakdowns you won't see anywhere else.